Include when you have a condominium, you should add a contingency for buyer approval, rights of refusal if there are any, and delivery and receipt of condominium documents, okay? So those those dates should be incorporated into your key date checklist so that you know you are meeting those deadlines. And the first one that I would add is what your deadline is to submit your condominium application. That is the first paragraph of the condo rider. If anyone's following along with the riders, it's paragraph 1. Okay. Um, you start with that box. Is approval required or is it not required? If approval is required, you have to check that box.
I'm sorry, Arianna, are you guys able to see my screen?
No,
No?
no, it's blue.
Okay, so hold on. I want to make sure you guys are able to see.
No, it's okay.
Now, are you guys able to see it?
Yes,
Awesome.
we are. Can
Okay.
you, any way to zoom in on that, or is it just because it's on my phone that it's smaller? Okay. No, no, no. I think that people can zoom in. They can pinch in, zoom in.
Okay,
Thanks, Majinde.
no problem.
Really appreciate you. Okay. So back to what I was saying. We're on the first paragraph of the condo rider. Okay. I'm going to switch over my screen. Stand by. If I can. Oh, that's weird. I really need to get a computer with a camera. Okay, wait, can you not see me anymore? Could you see me now? Okay, I guess I can't. There we go. That's what I wanted. Okay. So we're going over that first paragraph to start, right? Which is the paragraph where you select whether or not approval is required. Now, as buyers agents, we are submitting contracts and offers to sellers, right? We're submitting the first round or the first terms, which will either be accepted or countered by the seller. So, my suggestion to you to be a proactive agent and to do the best service for your client is to try and obtain as much information as you can, either from the MLS or contact the property management company yourself, or ask these questions of the listing agent while you're preparing the offer so you can complete the form as thoroughly as you can. And then any changes that need to be made will be made by the seller when they receive them. But I think it does you a much better service to get this information rather than sending a blank addendum, hoping that the seller completes it properly, and then you're going back to get initials, etc. So that's my first piece of advice is to try and get as much of this information from the property management company as you can. I would also request your governing documents at the same time. So when you're going to submit your offer or you're going to prepare your offer and you've communicated with the listing agent and you're asking these details, is approval required? What is the monthly maintenance or the quarterly maintenance, or how often is it paid? Are there any pending special assessments? These are the questions that you want to ask. You're going to also ask, do you have copies of the governing documents to provide to my buyer? Preferably in a digital format. You don't want to have to be lugging around hundreds of pages of governing documents. So, and don't be afraid to ask those questions. The listing agent should have that, and it should be part of their due diligence that they provide to you. And if they don't, it's a seller expense as a side note, but we'll get there. Okay. So first we're going to check whether or not approval is required. Then the first blank, the line that's blank is how long buyer has to get approved prior to closing. The default is 5 days. Now, that's good for the buyer, not so good for the seller because your contract is contingent up until 5 days prior to closing. So that means the buyer can wait 5 days prior to closing to submit an application, well, unless it says otherwise, and to provide approval. So that means that you've gone this whole transaction, And you, as a realtor, have been depending upon this deal to close. And the buyer, if they don't get approved by 5 days prior to closing, can cancel the transaction, deposits are released, everything is fully refundable. So you may want to think about um, writing in a different date for approval to be required. I mean, within reason, especially if it's a 30-day contract and the approval process could take 15 to 20 days. Maybe you say 10 days prior to closing. I don't know, anything to like limit that liability, or just be aware that the contract is contingent upon approval. The next blank is the deadline to submit your application. So the buyer does have a time within which they're supposed to submit the application. And if they don't, technically they haven't followed the terms of the contract, right? Any questions on that procedure or what the effects of that paragraph are? Okay. We're going to move on to right of first refusal. Not many condominiums have a right of first refusal, some do. The governing documents will tell you whether or not there is a right of first refusal. All that is that the association retains the right to purchase the property from the seller on the same terms that your buyer has presented. So let's say you have a cash offer for $100,000, closing in 30 days, 5-day inspection period. The association has a certain period of time within which they can present that same exact offer to the seller, and the seller would have to take it. So that's what a right of first refusal is. It gives the condominium the ability to maintain control of purchasing that unit under the same terms. There's limits. They have a time frame which they have to respond to the right of first refusal, and it has to be done in writing. So what happens if there is a right of first refusal, or what, you don't really have to worry that much about following that as an agent, except be aware of whether or not there is a right of first refusal so you can advise your buyer accordingly. That's it. Other than that, providing notice to the association, that's kind of on the title company and the seller. Okay. So you don't have to worry about presenting a copy of your contract to the board or following any procedure for that. When the contract is sent over to the title agency and they order the estoppel, there'll be a separate line item in the estoppel letter where it says association has exercised or waives the right of first right of refusal, or does not have a right of first refusal. So that will satisfy the notice and the requirements that you have to follow in the addendum. Any questions on right of first refusal? Cool. Fees, prorations, and litigation. Okay. So here again, you want to do your best to have this information up front, not only because you want to be able to make sure that you're having a fully executed contract, but these amounts make a difference on whether or not your buyer will qualify for this property. Okay. So like if you just leave that blank and you're assuming that the monthly assessments are $100 a month or whatever you was listed on the MLS, and it turns out it's $200 a month, well, your buyer may not qualify anymore, especially if there is financing. Your buyer only has a certain amount that they qualify for in a monthly payment. And in addition to your monthly payment of interest and principal to the loan, they're going to factor in insurance, they're going to factor in taxes, and they're going to factor in what monthly maintenance is. And if that monthly maintenance is double than what was disclosed, they may no longer qualify. Even if they have the money to cover it, you have to show that you make that in an income. So there is a difference between, oh, I can cover that difference, but can you cover it through an underwriting financing perspective, So something that, which all it means is that your monthly salary has to be such that you have enough to cover those monthly payments and those monthly fees. Okay. So that's another reason why to be very aware. Now, an anecdote I had a contract where the seller disclosed a certain amount of monthly maintenance, and it was way, way off. So the buyer ended up not qualifying, and we were out of our financing contingency. But in the end, because the numbers were not as they were disclosed, we were able to cancel the contract. Now, it's not so black and white, but just something to keep in mind. Like all of this stuff can have an impact on your buyer, especially when we're dealing with loans and we have deposits up for risk. You always want to double check and make sure that what is on your contract is accurate. Okay. The second blank will be if there's more than one association. So when you have these big developments, right, where there's multiple phases or different sections, Williams Island has a bunch of different certain country clubs and other associations that you have to be a membership. Or Turnberry, all these bigger places have multiple associations and multiple memberships. That second line would be where you would put either a sub association or some other association that gets paid on a monthly basis or whatever annual, whatever the other increment is. And then that third one is a recreation area. So in older condominiums, there would be these common areas, recreational halls that often were separate leases and were managed completely separate from the rest of the building. And that also sometimes can create additional fees. And as I mentioned before, um, developments with social clubs, golf memberships, tennis memberships, restaurant memberships. There are some developments that require you to have different memberships, and there are going to be fees associated with that. Okay, that's typically more of an HOA rather than a condo, though, but it depends. So we're turning to page 2. We're at the top of page 2 of the condo rider, and it says fees. Sellers shall, at closing, pay all fines imposed against the unit by the condominium association as of the closing date, and any fees the association charges to provide information about the property assessments and fees. So there's your catch-all. Any fines that exist against the unit is required to be paid by the seller. And as I said before, they're going to have to pay for the estoppel and copies of any governing documents. So it's just know that that protection is already there. Now, where it gets a little sticky are special assessments and prorations, because special assessments can be pending and not necessarily active when you sign. So in other words, if there is a special assessment proposed on the minutes, even if it was just brought up, like there was a board meeting and they're discussing replacing pavers around the pool or redoing the pool or something like that, that's been proposed but amount hasn't been given, that's a pending special assessment. And in box C, letter C, box 2, you're going to select who is responsible for those pending assessments. Okay, levied and pending. Okay, if you don't select a box, the default is buyer. So it's very, very, very important. That's like the most important thing that I would pay attention to, because you don't want to get caught off guard and then your buyer is all of a sudden responsible for something that a seller should have paid for. And just so you know, customarily, the custom is if the special assessment exists, it's a seller charge because it's something that the seller accrued during their ownership of the property. So sellers should not give you resistance in paying for a special assessment that's levied in full prior to closing. Now, that's also a negotiation tactic too, right? If you're getting pushback and the seller is saying they're not willing to pay for those levied or pending special assessments, well, then you may want to think about reducing your sales price to offset that expense that your buyer would incur. So nothing's a deal breaker. Always remember that. Things can be negotiated, but you've got to be aware of what you're up against. So you don't get caught and your buyer is kind of left with no leverage to negotiate when it comes time to closing. Okay. Seller has a duty to disclose any pending assessments. Okay. And that's in letter or number one. If special assessments levied or pending exist as of the effective date and have not been disclosed by the seller, then seller pays them in full. So failure to disclose doesn't harm your buyer. It would automatically be, if you can establish that they existed but they were not disclosed, the seller is going to be required to pay for them. Does that make sense to everybody? Cool.
Wait, no, it doesn't.
Okay.
Hi. So let me just,
Sure.
where does it say that if it wasn't reported at the time of the contract that the seller pays?
Okay, so we're in paragraph C on the second page of the rider.
Yeah.
Do you have the rider open? Okay,
I'm looking at my screen where
Okay.
you have, yeah.
Oh, right. Okay, so number 3, let me see where.
CI, you said. You were
Yes,
saying CI.
it's C1, 2, and 3, not
Oh,
I.
okay.
Sorry,
Oh, okay.
sorry. It's C1, 2, and 3.
Okay.
If special assessments levied or pending exist as of the effective date of the contract and have not been disclosed above by the seller, then seller shall pay such assessments in full at the time of closing.
Are disclosed by the seller. I don't see that not disclosed. I don't mean to be picking hairs.
No,
but
that's okay. It's okay. I'm going to read it again.
Levied or pending exist as of the effective date are disclosed by above seller.
Okay, that's 2.
Oh, have not been disclosed, 3. Oh, okay, I see it now. Thank you.
Yeah, no problem. Absolutely. Yep. Okay. If after the effective date, however, the association imposes special assessments for improvements, which was not pending, then the seller and buyer split it. And the seller shall pay amounts due before closing and buyer shall pay amounts due after closing. That's after the effective date of a contract. And that kind of makes sense, right? Because that's not something that occurred during seller's exclusive ownership of the property. Okay. One other thing that I wanted to bring to your attention is regarding litigation. So, what's important to keep in mind is that condominium associations are like little cities. Okay. So, when something happens in the common areas, um, car accidents in garages, accidents on, any of the roads through the buildings, can result in a lawsuit against the association. Associations are required to maintain insurance. So typically, what happens if there is pending litigation against the association, 9 times out of 10, it's going to be covered by their insurance policy. What's important to remember is maybe it's a huge multi-million dollar claim, and maybe their insurance policy isn't enough to cover the entire claim. And if that's the case, there could be a special assessment result from that litigation passed along all the owners to pay for any difference that's not covered by insurance. So it doesn't prevent you from closing if there's pending litigation against the association. You're just going to need some more information. You're going to need to know the nature of the claim, how far along is it, is there enough insurance to cover it. So not to panic, but because there are procedures that we take, but that's why you need to be aware of any pending lawsuits against the association. We clear on that? Okay. So moving along is to non-developer disclosure, and that's where you acknowledge that you've received copies of the governing documents or you have not. This contracts will always be voidable within 3 days after, if the buyer hasn't received copies of the documents. So as a listing agent, you want to make sure you get those so you can close up that voidability provision. And as a buyer's agent, you want to make sure you receive that too, to make sure that your client has had an opportunity to review those documents. Okay. If we turn to page 3, paragraph 6, this is where you request those documents or not. And again, it's at the seller's expense. The only other paragraph that I want to mention prior to moving on from this rider is that some units come with parking spaces, garages, storage units. You're going to disclose anything that's assignable with the unit in that paragraph 8. Does anyone have any more questions before I move on? Okay, so that's condominiums. We're going to move on to homeowners association riders. Very similar to condominiums because you have an approval period. You want to disclose the amounts for special assessments. You want to get copies of documents very similarly to condominiums. One thing I want to bring to everyone's attention is when it comes to homeowners associations, there's no requirement to cure violations. So let's say in a common violation in a homeowners association is like overgrown lawn. The home is painted the wrong color. You haven't pressure washed your roof. So now while that can be a violation against the unit, and if that has created a fine, the seller would be required to pay the fine, but not necessarily correct the underlying violation. I've never really run into an issue except this past year where a seller has said, I'm not repairing the violation. I'm not required to. I'll pay any fines, but I'm not curing. So that was kind of like a shock to me. I was like, but you have to. And then I went back and read the rider, and there is no requirement to cure. The only requirement is that you can't close with a lien and you can't close with a fine. So, sometimes if there's a lien, you can't pay the lien until you bring the property into compliance. But like, it's what would be a best practice is to add language requiring the seller to cure a violation and add that in as an additional term or add it into the rider, as opposed to like waiting and then having a seller saying they're not going to repaint their home and then your buyer has to pay for that. So just bringing that to your attention. Anybody have any questions so far? Yes, Priscilla.
Comment to make. There are some associations that we have dealt with during the past where you don't clear that violation and they won't provide the buyer with a certificate of approval.
Right. That's probably came apart because of this, right?
Right.
So
you give and you get.
Right. Like, okay, seller. Now what? So good to note, good to remember. But again, like if I'm preparing a contract, I would just add that language in there to avoid it. Okay, so paragraph 3, that's where you're going to write what the periodic assessments are. Either it's annually, quarterly, or monthly. Any special assessments will be listed there. Any other memberships that I was discussing before will be listed in number 6. Just like condominiums, if your buyer has a loan, they're going to have to qualify, and the monthly, quarterly, whatever the maintenance is going to have to be factored in to make sure that they can qualify for the loan, including whatever those fees are. So, okay, we're going to turn the page. Part B of the HOA disclosure, just like the condominium rider, has the deadline for which they need to provide an approval and a deadline for which you need to submit your application. Okay, that's in paragraph 1. Paragraph 2, same thing. You're going to list your special assessments. You're going to list your pendings. And if you're going to pick who pays what, okay? Those two boxes in paragraph 2, letter B, buyer or seller shall pay installments due after closing. If seller is checked, seller shall pay in full. If it's blank, buyer pays. The HOA is not as stringent as the condo rider. So it doesn't tell you if like something is not disclosed who pays for it, right? So there's a lot of information that's not provided here that's kind of left up for interpretation by the parties. So that's why my introduction to this review today, I led by saying it's so important to have this information on your own so you know what to ask for and you're not relying on representations. You actually have it. Now, and that's what an estoppel is for too. So as a title agent, I order an estoppel letter and that will tell me if there's any pending or levied special assessments, right? Or if there's any violations against the unit, but it doesn't tell me who's going to pay for it. You know what I mean? So having this information when you're preparing a contract will let you will give you the most leverage on how to assign who's going to be paying for what whenever it's possible. And typically all you have to do is ask the listing agent for the management company's information. You can call them, you can tell them that you're the realtor and you're putting an offer into the property and you need some information. Now they may not release it to you without some money. Maybe they'll require you to pay, maybe they won't. But also that's an opportunity for you to lean on the listing agent, you know, help me get you an offer. I need this information in order to present an offer to you. Typically they'll work with you as much as they can. Okay. So we're going to move on to the FHA rider unless anybody has any questions. Okay. So FHA loans are government-backed loans and so are VA loans. This is a combination rider for whenever you have an FHA financing transaction or a veteran VA loan for a buyer. So if your buyer is going to be using FHA money or a VA loan to purchase the property, you have to make sure that you attach this rider to the contract. So FHA, and because it's government, both FHA and VA are both government-backed funds. The requirements for the property are much stricter, meaning that the property has to be in much better condition and it's much more favorable to the buyer. Okay. It's just something to be aware of, especially if you're a listing agent. It's not to say that you shouldn't take an FHA or VA offer because often the programs are great and they get their buyers approved. Okay. But the property has to be in such a condition that it's going to pass a FHA or a VA inspection. And to that end, paragraph 2, the first part of this page, paragraph 2 deals with FHA. Paragraphs 2 and 3 deal with FHA. Paragraph 4 deals with the VA. So it's one or the other. You're not going to select 3 and 4. It's going to be 3 or 4 when it comes to what you're dealing with, okay? The first thing to be aware of is you have to put an appraised value in paragraph 2. So, I'm sorry, appraisal repairs, not just an appraised value, because the appraised value has to be it will be the sales price. So it says the cost to seller for appraisal repair shall not exceed blank, which cost is in addition to the cost required to be paid for in the paragraphs in the contract. So there I would write some amount, $5,000, some amount that will not exceed the cost to repair the property. Now, if they do exceed, if it does exceed that, the seller will not be obligated to make those repairs. They could cancel the contract instead of having to make those repairs. Something to be aware of. For the FHA financing rider, that's where you put the appraised value in that blank, and I would just make it match the sales price. That's what you want. You want the property to appraise at sales price. You're not worried about it appraising more than the sales price. You want it to just appraise at the sales price, okay? If the property does not appraise at the sales price, the buyer has the option to proceed, but the loan will be valued based on what the appraised value is. So generally, the buyer will have to have the capability to come out of pocket the difference. Okay. When it comes to FHA financing, generally, the seller provides a 3% credit towards buyers' prepaid expenses and closing costs. So in that section that says fees and prepayments, purchasers shall pay all loan expenses except tax service fee and shall be paid by seller up to a maximum, I would say, of 3% of the closing costs. And again, this is all negotiable. This is what we're going to submit back. FHA loans typically have some higher closing costs. That's why it's expected for a seller to provide the credit at closing. Then the rest of the rider just discusses appraisal repairs and what happens if the seller chooses not to make those repairs, and you can cancel the contract, as I said, and get your deposit back. And there's those built-in contingencies. Now, when it comes to VA, the important thing to note is on page 2 of the rider, letter A. Whenever you have a VA loan, the buyer is prohibited from paying certain closing costs. So no matter what, this is like a complete non-negotiable, and it cannot be on the buyer's side. So seller will pay for the WDO inspection, a tax service fee, underwriting fee, doc prep fees by the lender, recording fees, for the any assignments of the buyer's mortgage. So in your contract, it's already built in there. So when you get to closing and there's certain fees that appear on the seller side because it's a VA loan, they've already agreed to it by signing this addendum. You don't have to worry about getting a seller to agree to that. Whether they know about it, you know, the duty is on them to read their contract, to know what they're signing, but just something to be aware of. Now, these costs aren't like, we're not talking about tens of thousands of dollars. It's typically like anywhere from $500 and $1,000 in closing costs that end up getting passed along to the seller when you have a VA loan. Any questions on FHA riders? Okay. Appraisal contingencies. Okay. So this rider is interesting in the fact that you would think that an appraisal contingency is built into a financing contingency, but it's not. So in other words, you can have a contingency for a contract that a purchase and sale is subject to financing, meaning that your buyer has to qualify for a loan for a certain amount that's disclosed in your contract. But that doesn't mean that the property has to appraise. So sometimes what can happen is that you have a buyer who wants to buy a property with a loan, but maybe they have enough money to buy it cash, right? But they just are choosing to get a loan. In that instance, they wouldn't be denied the loan because they have the ability to pay the difference out of pocket. So you wouldn't necessarily, unless they received a loan denial letter, you wouldn't be able to cancel the contract because the property didn't appraise. Does that make sense to everybody? That nuance, that distinction between the value and underwriting a buyer for qualifying for a loan? Okay. So the advantage that you have on adding an addendum, like an appraisal contingency, safeguards your client. It adds an additional out that if the property doesn't appraise, the seller can either reduce the sales price, the buyer can still choose to continue the purchase, or the buyer can cancel the contract and get their deposit back. That's not the same as a financing contingency. I just really want to stress that. Okay. The last addendum or rider that I added, just for you guys to be aware of, is a buyer's attorney approval. So there's also a seller's attorney approval rider. So this is really great, especially it enables you as realtors to go ahead and proceed with negotiations, especially if there's a property that has a lot of action, right? There's a lot of offers going back and forth, and you want to be able to get your client the best service. Maybe you're working and it's 9 o'clock at night and you still want to submit that offer, but the buyer is like, I want my attorney to review it. Okay, well, the attorney either doesn't have time to review for a couple of days, or definitely doesn't have time to review at 9 o'clock at night. Okay, so whatever the case may be, you can use this rider to make the contract contingent upon review. So what you're doing is you're putting some terms in front of the seller, you're showing them that you're serious, but you're also reserving the right that the contract is contingent upon the buyer's attorney to review it. Same thing for a seller. You know, the seller can accept your offer as a buyer, accept your buyer's offer, but attach this rider, preserving the rights to have their attorney review it, subject to changes. You know what I mean? So, you know, don't panic if you can't get a hold of the attorney, which is more often than not. You know, everyone's busy, and you can't always predict what an attorney's schedule is. So the way to help come up with a compromise is to use these riders. Now there's a drop deadline. You know what I mean? You can't. It's not for until closing. It's typically 3 days. I wouldn't do more than that. You probably would make a seller angry. What's up?
Yeah, so I'm just wondering why you would throw this in. To me, it would scare the seller when you have the contingency period anyway, right?
It's very true. You can always use the inspection period, but you're also just being forthright. I think a good listing agent wouldn't get concerned and would say, okay, let's look at the terms of this offer. If this is a better offer than what we have, we'll wait and give this buyer an opportunity to have the contract reviewed by their attorney before we automatically reject it and take something else. That's all.
Okay.
But yeah, you are right. And oftentimes I do have clients that do that and send me a contract during the inspection period. But it's also like, you don't want to be the realtor that cancels during inspections for no reason. Do you know what I mean? Like, your reputation is also on the line too. And you don't want to, do you know what I mean? Like, so it's also creating goodwill and shows a level of professionalism. And, you don't want to just cancel 24 hours after you've signed a contract during an inspection period.
Okay.
But great question. So that's my little rider review. I think the next time I teach this class, I'm going to pick up some different riders to go over. Maybe I'll keep the condo rider in there because I think it's just so important, especially for our market. But if there's anything that you guys want to see me review, if there's anything that specifically you guys want me to go over, maybe I'll do the contract class again in December, and then I'll revisit riders again in January. And yeah, go ahead, Paige. What's up?
Question. I thought with the FHA VA rider that it's redundant, because isn't it in the contract that financing happens or doesn't happen anyway?
Yes, but there's provisions that aren't addressed that apply specifically to FHA and VA that need to be agreed on. For example, those fees that that the seller is required to pay only appear in a VA rider.
I
So
see. Okay.
you need to, and also a FHA lender and a VA lender will reject any contracts that don't have that specific rider.
Oh, okay.
They'll totally reject the contract and they won't accept it. So they won't even see it as a valid contract until you have that rider added in there. Then you're
Okay.
chasing your seller down to get it signed.
Okay. Thanks.
Yeah, absolutely. It's great questions, really. Well, I'm exhausted. But if there's anything, does anybody have any other questions? Anything that I didn't cover? Anything that you want me to explain more on? Let me know. I'm going to put my email address in the chat. You can email me, you can call me for whatever you need. Oh, wait, hold on. There's chats. Let's see. Please share the forms. Okay. The forms are available in that email that went out to everybody. They're PDFs. You can click them. So you should be able to save those forms for future reference. And I think that all these classes are also recorded for future playback, I believe, as well. So
Yes, they
yeah,
are recorded. And when we get the recording from Zoom, they typically send us the recording when it's ready. I send it out to everybody in the office. It's going to be on the Facebook page, and it's also going to be via
awesome.
email.
Great. Thanks, Madame. So that's awesome. So there, you can listen to me again and again. Cool. Before I sign off, last chance. Anybody have any questions for me? Thank you, everybody, for your attention and your time today. I appreciate it. I think the more that you guys attend these classes, the more questions that you ask, the better prepared you are going to be to review and present your offers. And it'll put you a leg up to get to that closing table. And that's the goal. So if there's anything else anybody needs, let me know. And I'm available. I'll be in the office. Hannah will be in the office tomorrow, Tuesday. I will be in the office on Thursday. So I look forward to seeing you guys around, or give me a call. Thanks
Thank
again.
you.
I have
You're welcome.
Caroline.
Sure.
Your email is not working properly for me. Are you part of our office?
Yes, it should
Yes?
be.
Okay.
Yeah,
So
but I think I realize I think I have those documents
if you are
stored.
part of our office, then you should have it already.
Yeah.
Awesome.
Okay, thank you.
And Rosie, I think she left. I'm sending it out. Okay. Thank you, guys.
Thank you all. Thank you all for your time and attention, and happy closings. Take care. Priscilla, I owe you something. Yes, I do. Okay. Bye, everybody.
Yeah, docs to review.
Yes, I do. I saw it in my email and was like, oh God. All right. I'll see you soon. Bye, guys.